they have not been indicated in the so-cause notice, and yet the punishment is on that.
Set aside and remand the matter.
But it's absolutely no finding by the appellate court, appellate authority.
Determine the amount.
No, exactly. That is my sir. That is also vague. Tomorrow they may say, I will remain under the impression that it was worth 1,000. Tomorrow if they come say, no, it is worth 1 crore. It is all vague. It is all in the air.
This order is operating.
My lord, it is interim order is on. Hello. This writ application is
Lord, I am appearing on behalf of the state in this case. Lord, I have gone through the pleadings. Filing supplementary counter affidavit is required. Supplementary counter affidavit is required.
Right?
Because, my Lord, a specific query has been made on earlier date 23/8/2019. That has been not replied in this counter affidavit. Though the query has been made, is not part of pleading of writ petition. But anyhow, that is a query of the lordships. So that should be replied specifically. That has not been replied. So, my Lord, I feel.
No, what was the query?
Query was, my Lord,
the ground that is taken 4.2 and 4.3, they have not been indicated in the so-cause notice, and yet the punishment is on that. Even in the memo of appeal, I have raised that these are the points. Even the appellate forum is absolutely not dealing with, rather the appellate forum has not dealt with any of my grounds. So this was the query, initial observation of the Honorable Court made on 23rd of August 2000, and on that ground, it had stayed the operation of the order. Because I am class 1 contractor, I have been getting...
Where is the appellate authority order?
My lords, that is Annexure 7 at page 61. My lord would be kind enough to say. And the facts of the case are that, my lords,
Which paragraph your appeal has been considered?
Lords, kindly see, my lords. Kindly see at page 64. The only 2 paragraphs at the bottom. स्पष्टतः पथ निर्माण में संवेदक द्वारा अपर्याप्त बिटुमेन का प्रयोग किया गया है. There is absolutely no consideration in the earlier parts. They are only grounds which I have agitated in the appeal. And the finding is there in one line कि bituminous प्रयोग नहीं किया गया. And second, उपरोक्त वर्णित परिस्थितियों.
No, in which paragraph? Para 8.
Para 8, the one line is there. Yes.
Set aside and remand the matter.
But it's absolutely no finding by the appellate court, appellate authority. And even that ground remains, my lords, that in the initial so-called notice, if my lords will be pleased to see the so-called notice, Annexure 1 at page 17, in that this 4.2 and 4.3 on which I have been punished.
No, which is the order subject matter of appeal?
Lordships, kindly come to my lords. The Annexure 5 at page 47. Now, in this, if my lord would be kind enough to come to page 51.
What is this gist of this page 47?
The gist is, my lords, the allegation is that a work worth 9 crores of rupees was given in 2012, which, my lords, I had completed within 13 months. And thereafter in 2017, this after 4 years period.
No, you have completed in 2011.
2011-12 was the contract period which I completed the contract in 13 months. And after that in 2017 they are issuing us, after all payments have been made, that at some points, kilometer number 3, the layer of the bitumen is not so thick as it, which is negligible according to Annexures 2 and 3, their own circular and guidelines. It is mentioned that that can be...
No, such inspection was undertaken on what date?
The inspection, they say that it was taken in 2014. But the so-called notice is issued to me in 2017. That is why, my lord,
What is the reason assigned for delay?
no reason. After 3 or 4 years, they are issuing a so-called notice. And on that day score, they have punished.
Inspection in the year 2014.
It was all behind my back. It was all behind my back. And in 2017, they are issuing such a letter. And then when I give a reply, they do not consider and they punish me. I go in appeal.
What is the punishment?
Punishment is, my lords, for suspension of the license for 2 years and for recovery of the quantum of bitumen which has not been properly used. Can you see that?
Determine the amount.
No, exactly. That is my sir. That is also vague. Tomorrow they may say, I will remain under the impression that it was worth 1,000. Tomorrow if they come say, no, it is worth 1 crore. It is all vague. It is all in the air.
This order is operating.
My lord, it is interim order is on. And interim order, I feel, my lord, interim order should be, that is the basic, that he cannot improve or change the laws.
Taken. In the instant petition, petitioner has prayed for the following relief. He was allotted work, road construction work worth about a sum of 9 crore in the year 2011-12. He had completed work, the work which was allotted to him within 13 months from the date of contract to start. In the year 2014,
I'm sorry, 16 months.
16 months.
One more fact, my lord, even the DLP, defect liability period, came to an end on 31st of March 2016.
Right before the appellate.
I am submitting for my lord's consent. That if also may kindly be recorded. Before issuance of charge memo, that the date had already expired 1 year before that.
What has expired?
The defect liability, if there was any defect they could have pointed, I would have, that was expired on 30th.
Inspection.
Inspection, they say it was in October 2014.
That is within time limit.
Within time, but behind my back,
Already.
no information. Information only in 2017.
Attention cannot be taken.
Lordships.
16 months.
Lordships.
Thereafter, everything was settled among the respective parties. However, in the year 2014, the concerned official is stated to have undertaken inspection of the work executed by the petitioner and found certain substandard work. The result, show cause notice was issued in the year 2017 and thereafter proceeded to suspend the license for a period of 2 years on 19/12/2017
Reply I have given. Reply I have.
And with reference to substandard work, certain amount was required to be recovered from the petitioner. Feeling aggrieved by the order of suspension of license for a period of 2 years and a proposal for recovery was subject matter of appeal before the appellate authority. Appellate authority passed the order on 19/3/2018 by Annexure 7 to stop perusal of appellate authority's order. There is no consideration of petitioner's appeal. Like each of the contentions have not been dealt with, as is evident from paragraph 7 and 8.
8 and 9.
8 and 9 of the appellate authority's order. Appellate authority order is amenable to judicial review. Therefore, appellate authority's order should have been speaking and a reasoned order in order to appreciate whether his or her order is amenable to judicial review or not. Full stop. Therefore, there is a depth of reasonings, and in not considering each of the contentions raised by the petitioner in his memorandum of appeal before the appellate authority. Full stop. Next paper. At this stage, it is necessary to take note of text code of Kranti Associates so and so. Para 47 reads as under. Full stop. In the light of principle laid down by the Apex Court decision, we find prima facie the appellate authority's order is not a speaking order. Accordingly, it is set aside and matter is remanded to the appellate authority to consider petitioner's appeal afresh in a period of 3 months from the date of receipt of this order. So the appellate authority is hereby directed to take note of each and every contentions stated in the memorandum of appeal and proceed to pass order strictly in accordance with relevant materials and rules. Writ petition stands allowed.
The interim order until adjudication by the appellate authority. The interim order.
Order of suspending license and recovery shall not be given effect till final order is passed by the appellate authority.